The title of my little talk is on lawyers in expected and unexpected places, foregrounding the English legal profession in social and political histories of the 1970s. And so when I saw the title for this conference about legal history in unexpected places, it immediately drew my attention. I've just submitted a history thesis on the 9th of November, so very new, and it explores aspects of Britain in the 1970s. And I do that through the lens of the English legal profession. I should say as a slight disclaimer that I'm a solicitor myself. So I explore the English legal profession and its intervention through the civil law in a range of issues which emerged from the dislocation of the 1970s. My thesis focuses on developments in welfare law, calls for a Bill of Rights, debates around trade union powers, and the creation and implementation of equalities law. And in doing so, I've tried to make the legal profession into a very human characters and not just people that mediated the law, so important that was, and so how they were affected by the events of the 70s, but also how they affected what was going on in turn. So if you can see that slide, that's the picket line of the Grunwick strike, which went on in the mid to late 70s. And this is taken in 77. And you'll see there, you've got John Bowden, who was a solicitor from Thompson's firm. You've got Harriet Harman, also a solicitor. They were both from the, and also Jeremy Smith, who is a barrister. And they're all from the Brent Community Law Centre. So they're also so it's listed in this period of almost exactly where they should be, but also missing from some of the social and political histories of the time that I was reading. So I'm going to turn first to the difficulties of writing about lawyers in the social and political histories of the late 20th century, but also then a few moments just on the surprising places where they were turning up in the period. So historians of 1970s Britain often explore the law. It's really hard not to. From the perspective of the civil law, it was expanding in myriad ways, and a wider range of people had property to bequeath or transfer. The welfare state was growing. It meant it was becoming more codified. It meant that people needed help with administrative tribunals, and the law was advancing further into people's lives with this development of anti-discrimination legislation, just one example. But lawyers are often not visible in these social and political histories. And one of my thesis's arguments is that as social and political historians historicise legal developments, and they're now moving into the 80s and the 90s, which I was born in the 70s, so like the 90s seems like recent times to me. But it's useful to think about the law, but also about the profession that mediated it. So individual lawyers are often feature prominently in historical scholarship. They've long been at the forefront of political campaigns. Legal training followed by a career as a politician or a campaigner is a well-worn and well-documented path, and I'm sure we can all think of examples, not least our current Prime Minister. But less visible are those who remained members of the profession and use their legal skills in their engagement with the social and political life of the nation. So why are these lawyers often not visible? One possible reason for this is because historians, social and political historians, have not yet had to grapple with the law because it wasn't so pervasive in some of the senses of modern Britain. It could all be a sense that lawyers, all they do is implement the law. And we all know that that's right from a technical and client care perspective. We implement the law, but we also know that following the Second World War, there was an increasing change in the way that lawyers were focusing their activities. It could also be because of an earlier turn, which was very necessary in social and political history, away from elite histories. And by focusing on lawyers, my thesis doesn't seek to recover actors who are marginalised, but almost those that were hiding in plain sight. So I've just put a couple of books here. One, you'll probably all be aware of David Edgerton's book on the rise and fall of the British nation. And in that book, he says that it's rightly observed that for most of history, it's the history of elites. But for 20th century British history, almost we know more about the non-elites than the elites. And this, he posits, is because histories reflect visibility in the public sphere. And again, lawyers are good, and with some notable exceptions that we can probably think of, at making themselves invisible. And the book there on the right is a recent book by Luca Falciola from Columbia University, and he's talking about radical lawyers in the United States. And he says when lawyers enter the picture, they're often granted only a secondary part hovering in the background. So very few lawyers have careers which involve multiple high-profile matters or which are notable for other reasons, and that's why sometimes also histories it's easier to recover maybe sometimes barristers because in modern British history because of the maybe slightly more public nature of their work. So as I say, my thesis has sought to place the legal profession, barristers, solicitors, academics, law officers, judges and students all within the events of the 1970s and make them into a very human group. So I was thinking about where we might expect to find lawyers in the post-war years. And here the legal profession appeared to sail in many ways through the mid-20th century, unlike, say, the medical profession, which obviously went through a real change in those years. And though calls were made for lawyers to be nationalised, or the legal profession to be nationalised, that didn't really gain much traction. But by the mid-1960s, things were beginning to look a bit more challenging. The introduction of legal aid was changing the nature of legal practice and also bringing greater external scrutiny. High street solicitors were facing twin challenges of the social and financial pressures of the day, and they also had a regulatory body in the Law Society, which many of them felt was hampering them rather helping them. And that led to the setting up of a group called the British Legal Association, which features in my thesis, and they're an interesting bunch. There was also a growing realisation that they were working for an increasingly narrow section of society and that they needed to broaden this out. And many of you may be aware of the pamphlets from 1968, Justice for All by the Society of Labour Lawyers and Rough Justice from the Society of Conservative Lawyers, beginning to think about how you could widen that base. You also saw in 1967 the removal of the cap of 20 partners on firms, which those bigger commercial firms were taking advantage of to grow and respond to the financial opportunities, especially towards the 1980s. So surrounding all of this, the changes within the profession was an increasing use by cause groups seeking to use the law as a way of making arguments for social and political change. So how was this changing the places where we might see lawyers? So if we bring to mind the ways that lawyers were operating, I mean, probably hadn't changed for decades, but the thesis of the legal profession of my thesis was having something of what you might call a 1970s moment, and the profession was expanding. And if you think about the breadth of it, from these increasingly expanding commercial firms to law centres, that's kind of a greater breadth of ways of being a lawyer during the period. So I'm now going to turn just for the rest of my time just to two unexpected places maybe where lawyers were appearing. And one area that I thought I would bring up in this forum is universities. So now it is obvious that law is taught in universities, and that wasn't always the case, particularly in the 60s and 70s. And it wasn't also obvious what a legal education would comprise. And I'm sure many of you here are aware of the expansion of law teaching and the number of topics that have been covered. But in the wake of the Robbins report of 63, there was a number of ramifications for legal profession. You know, the expansion of the universities impacted the legal profession, and this expanded the number of legal academics. One set of figures I found said that in 1963 there were 272 legal academics, and by 1981 there were 1,282. And I'd say that there were two key interventions which these academics were making. One was to change the profile of young lawyers joining the profession and what they expected to do during their careers. More people with law and other degrees contributed to the graduatisation, if you want to call it that, of the profession, something that was contested at the time, and as you all know was in part reversed in 2021 with the SQE exam. So some argued that legal studies should be vocational, and the details of what was required to qualify as a lawyer was the subject of great debate, including by the Ormrod Commission, which examined legal education in 1967, and I don't think really put that all to bed. So some legal academics, such as Harry Street from the University of Manchester, contributed to ideas about how the law and the profession could adapt to changing society. His report on the operation of race relations legislation in North America was influential in opening up the space for the 1967 restatement of the Race Relations Act 1965. So such academics were melding law and social sciences, and they also provided a fertile ground for importing legal ideas from the US, the Commonwealth, and from Europe. And they also contributed to the development of new legal disciplines. And I've got a photograph here of Warwick, but Kent and Warwick thought about law in context, law as a clinic, and provided a law clinic experience. So by the mid-70s, the University of Sheffield was offering law and welfare state MA as one of it was offering a law and the welfare state as one module of their MA in socio-legal studies. And the University of Leicester offered a one-time course, one-year full-time course in welfare law from October 1976. And the course was designed to provide a working knowledge of welfare law and practice, with special reference to social security law, housing law, the law relating to child welfare and protection, and the processes and institutions of enforcement and redress. So all this change in education, the new generations coming through, this new education and this new expectations of what being a lawyer could be. One aspect of this, one change that it led to was the ability of lawyers to operate in new ways. And the 1970s is known for its proliferation of cause groups, as socially and politically engaged generation moved from 1968. So I think the grand visions of 1968, peace and ending war, to more tangible and ways of contributing. The 1970s saw what had been seemingly settled areas of national life opening up to new scrutiny and debate. And the civil law was playing an ever wider role in mediating an increasingly complex range of these relationships. And though strategic legislation didn't really get going until the 1980s. So I think Amnesty say on their website that they started using strategic litigation in 1987. Lawyers can be found in groups such as the Child Poverty Action Group, where Henry Hodge launched the test case strategy in an attempt to change government policy and draw attention to the failings of the welfare state. They can also be found on picket lines, as we saw at that first slide, and based in poorer communities. They could set up a group such as Rights of Women to advocate for women's rights. And this was not always welcome in what you might describe as the mainstream of the profession. Many of these, what you might call mainstream lawyers, had a very clear view of what a lawyer should be, and maybe these lawyers from the Kensington Law Centre were not that. David Napley, who was the president of the Law Society between 1976 to 1977, said that once legal advice is linked to political beliefs, it will be the kiss of death for all that is best in the administration of justice. Now, Napley had been a Conservative parliamentary candidate, and his comments were aimed as those he characterised as being on the left, particularly those in law centres. But he seemed not to recognise the political nature of his statements. But though ideas of politicisation were seen then as perhaps now the preserve of lefty lawyers on the right, or what you might call a conservative sensibility, were also turning to the law or to legal levers for their causes. So lawyers such as Lord Hailsham and these chaps from the British Legal Association made use of new media opportunities to challenge the policies of the Labour government and the power of trade unions and what they perceived as the deleterious impact of creeping socialism on British democracy. Hailsham used his media savvy to argue in newspapers and on TV for constitutional change. So perhaps you'd expect to see Lord Hailsham on TV, but perhaps you wouldn't have expected to see him there in the context of arguing for what was, in fact, quite radical constitutional change, given his capital T Tory kind of views on the law and his sentimental attachment to the Constitution. So turning back to my initial point about visibility of lawyers, there's a book here is written by Norris McWhirter about his brother Ross. And whilst the Brent Community Law Centre helped pickets who were protesting against the employer at Grunwick. The National Association of Freedom, which was set up after Ross was assassinated in 1975, were helping the employer. And papers from the archive show a John Robbins, who was a partner in Trowers, Still and Keeling, in correspondence with the government on behalf of the Grunwick employer. And he was described elsewhere by Ross McWhirter as his favourite litigation solicitor and as being splendid. But it's quite hard to recover John Robbins's reasons for getting engaged. You know, it was obvious why the Brent Community Law Centre lawyers were there, but what about John Robbins? And you know, it could have just been that he agreed with the objectives of NAF, or it could be that they were a really good client. And one stage they went to the House of Lords, so obviously a very interesting client to work for. But in his description of Ross's funeral, which was held at St Paul's Cathedral and described in this book, the funeral was in December 1975. Norris describes some of the networking and the people that came to the funeral, and alongside other lawyers, a number of litigation specialists were there who had helped him with Ross with his 11 High Court and 4 other actions. And he says that John Robbins was there and Leonard Bloomstrand, but there's also this tantalising snippet which hints at wider connections. He says that both branches of the legal profession came, including Patrick Neal, a chairman of the Bar Society, and his wife Caroline, whom Ross found so splendidly unsecretive about her misgivings on Britain's entry into the common market. But for the modern social and political historians, recovering these networks is really hard. So just to conclude, I'd say that by the early 1980s, the lawyers were appearing in both expected and unexpected places, but overall they were much more visible and engaged in the life of the nation and in the debates of the day. Thank you.